Ladies and gentlemen, I know that post-lunch is perhaps not the easiest moment to focus, but there is still some coffee left there, and I think we should start so that we have plenty of time for discussion. This is our second panel, and hopefully by now you have some level of reference in terms of what loss and damage is about, even though it is not defined. We clearly have seen the progression of how it has evolved over time and how it is almost uncontroversial that somehow we do have to have a proper framing between whatever loss and damage actually means, whether it is some level of pure voluntary financing or some disguised version of technical assistance or some kind of fund, which is not a fund of strict liability like we find in many other places, but it is something which is still work in progress, and yet juxtapose it with something which is very well established, which is the law of state responsibility. As you will also know, the reference point whenever we think and speak about the law of state responsibility are the ILC articles of 2001, too often conceived as a fully just codification of international law, just a pure reflection of customary international law. Well, I may be a spoiler surprise. Here and there, big spoiler alert, there are things that have been left very much like a hanging fruit. And there are things which haven't quite been developed and detailed enough. And I think part of the discussion that we're going to have in this panel is exactly how to pick on some of those controversial, most complex topics that, for example, the ILC has sort of tried to circumvent or leave hanging out there. So I have a great pleasure to welcome four speakers who, in a good tradition that we have just set up in an earlier panel, come from different continents. We have a speaker from Spain, a speaker from Brazil, and a speaker from University of Leeds, from United Kingdom, and from North Macedonia. That's quite a nice, diverse group of speakers. But more importantly than that, they have presented already very thought-provoking, detailed abstracts of their papers. They are at different stage of completion, I would say, between the four. But I think there is a nice complementing message among all of them. And that is precisely to try to understand how reparations, and as you may know, there are different forms of reparations out there, how they can really be the most adequate form of redress to climate change. So how can we use some of the existing law out there in terms of general secondary rules and perhaps give them a tweak or a twist here and there to adjust to the particularities of the breach, but also of the injuries that result from the failure of states to undertake proper mitigation and adaptation measures. So I have already spoken for 2 or 3 minutes. Without further ado, our first speaker, and I will introduce all of our 4 speakers in very briefly, because I'd rather give them the floor to speak. María de Arcos Tejerizo is a lawyer from Spain with Pérez-Llorca Abogados, and she is also the graduate of the Advanced Master of Laws in Public International Law, and a former intern with the Spanish Permanent Representation to the Council of Europe and various international law firms in Madrid. Laura Gonçales, who will be joining us online, is a lawyer from Brazil with the law firm Machado Meyer, and a master's student in international law at the Pontifical University of São Paulo. Susan Ann Samuel is a lawyer from India and a PhD candidate at the University of Leeds, researching on climate politics and exploring international normative change in the climate crisis through an interdisciplinary lens. And Marko Guteski is a lawyer from the Republic of North Macedonia, who specialized in environmental law and public international law. And his work experience includes engagements with the law firms, LGP lawyers, and various NGOs. And he is a recent graduate of Queen Mary University of London. I probably have some level of personalized connection with most of these people, even though I didn't know about that. But it's really nice to be presiding this moderation in this discussion. Without further ado, Maria, we've discovered our point of connection already. You have the floor.
So thank you very much, Vlad, for your kind introduction. And it was a really pleasant surprise to see that you were the moderator of my panel, actually, because as I told you earlier, you were my professor a few years back in Leiden University while I was doing my LL.M studies there. So it was a great pleasure to, and it is a great pleasure to meet you again here. And I want to extend my appreciation to the rest of the members of the organizing committee of the conference, Miriam, Armando, Maria Antonia, and of course, Camilla and Eneas, whose help has been invaluable in order to make this event happen today. And thank you to everyone that is here with us physically or online, because it is important and very crucial that we speak and discuss on these pressing topics for humankind and future generations. So as Vlad anticipated, I am a Spanish lawyer. I work in civil litigation, commercial litigation, and torts, among other issues, and international arbitration. I will speak on issues on state responsibility because I also have a background in public international law, and more precisely on the duty of reparations of states and how this duty of reparations may arise in scenarios of multiple causation, as is the case of climate change. So the ideas that I can bring to the table as a practitioner are those challenges that I encounter frequently, as we all lawyers do in practice, which are the nitty-gritties of litigations that Armando mentioned earlier in the previous panel, the never-ending discussions of attribution, causation, etc. So I hope that you ate well because we are entering into that discussion. So what I want to explore in my draft paper is whether the estate and to what extent the estate may be held liable to pay compensation. And we have also seen that compensation is only a small part of all the reparation spectrum that climate victims suffer, but whether and to what extent estates may be held liable to pay reparations for damages that they have not caused in their entirety, because they have been caused by several contributing factors that have contributed to the injury as a whole. This is a crucial question that at some point will have to be dealt by international courts and tribunals, and hopefully we will get some clarity from them then. But the allocation of damages is a very pressing discussion in terms of secondary obligations under international law, because this is essential in order to apply some of the most basic principles of environmental law that we have mentioned in the earlier panel, the polluter pays principle or the common but differentiated responsibilities approach. This is also essential in order to ensure that victims from climate catastrophes and climate change get full reparation and effective redress. So climate change is a paradigmatical example of a legal issue that has been caused by several contributing factors and concurrent causes, both coming from states and, even more importantly, non-state actors, corporations. We all contribute to climate change. We are all responsible to some extent to the consequences of climate change. And we have seen, as the keynote speakers noted earlier on, that the damages, both the material, economic losses, loss of productivity, and even loss of life account for trillions of dollars. So the focus of this presentation will be to what extent, let me see, because I cannot pass my slides. now. So the focus of this presentation would be to deal with issues of allocation of damages in interstate cases or investor to state arbitration or private claims against states, in order to see whether the state has the obligation to pay for those compensations. Some questions that may be posed in this regard is, are the states, may the states being exempted from liability if they have, if their contribution to climate change has been minimal, or maybe can these states can their liability be attenuated or otherwise reduced in the case that, for instance, non-state actors' actions have been decisive to provoke the climate injury? First of all, and to see the legal framework of this question, and to see the legal, and to see the legal framework of this is the law of state responsibility. I have to draw the distinction between, on the one hand, the declaration of the state responsibility, and on the other hand, the duty of reparation of states. Well, to see the legal framework, we have to draw a distinction between the declaration of state responsibility and, on the other hand, issues of the duty of reparations of states. And the articles on state responsibility are quite clear as regards the former, because Article 47 clearly states that when multiple states have caused a wrongful act, they can all be held responsible as a whole and separately. However, the articles on state responsibility are not that clear as regards whether these responsible states have the obligation to pay for compensation or to owe reparation more generally to the injured state, or as a whole, or by contrast, whether the reparation should be adjusted on the basis of the degree of contribution of each responsible state. The ILC commentaries, specifically the commentary to Article 31 of the Articles on State Responsibility, suggest that customary international law is inclined to hold one state fully accountable, and I quote, for all the consequences not being too remote of its wrongful conduct, unless the injury can be shown to be severable. The ILC commentaries also consider that the state practice is not, it does not support the reduction or attenuation of reparations in cases of concurrent causes. However, as some scholars have noted, including, I think, you, Vlad, actually, the international judicial practice is far from settled in this matter. For instance, we have the UN Compensation Commission panels following Iraq's invasion of Kuwait, which awarded damages to the extent that was attributable to Iraq, but reduced the damages that were caused by other contributing factors. The ICJ, on its part, has been clear by requiring a sufficiently direct and certain causal nexus between the damage and the wrongful conduct, as it was stated in the 2007 Bosnian genocide case, or more recently in the 2022 reparations judgment in the armed activities case. So in light of such an unclear practice, I wonder whether the legal standards that are applicable to the duty of reparations in the law of state responsibility are well suited to provide victims of climate change with full and effective redress. And the answer is probably not. In a different context, in 2003, in the oil platforms case, Judge Sima issued a separate opinion which directly engaged with the issue of how to look into legal solutions for the problem of multiple causation. He looked into domestic systems and he referred to the principle of joint and several liability. And although it was not, the reparations were not at issue in that specific case, he seemed to suggest that had the case proceeded to the reparations phase, the US, as the injured state, could have invoked the responsibility of either Iran or Iraq for the damages caused to get full reparation. As such, he articulated this doctrine of joint and several liability, which in his view amounted to a general principle of international law drawn from domestic practice, and which could be applied insofar as the damages were non-severable in nature. In my draft paper, I put forward the doctrine of joint and several liability as a potential legal solution for full and effective redress of victims of climate change. This doctrine, as I mentioned, draws from tort law principles, both from common law and civil law jurisdictions, when the causes of the damages are indivisible among several tortfeasors or wrongdoers. In such case, each victim may only sue one state to be held liable to get full redress for the full breadth of damages, despite that regardless of the fact that the actions of this state alone may not have led to the injury. While I acknowledge that first, it remains to be, even at the domestic level, an exceptional concept, because the general rule, of course, is several liability, and even though it is not easily transferred to the domain of state responsibility, and we have to be careful about that, I explore the efficiencies and advantages that it may bring in order to ensure full reparation of victims of climate damages. And some of the advantages that I that I indicate in my paper are the following. First, that the principle of joint and several liability would ensure or would alleviate the victim's burden to get redress in order to prove, for instance, issues of causation or the quantum of damages. We can see this, for instance, or this is exemplified in the ongoing litigation in Germany in the case of a Peruvian farmer, Yuya, who has sued a German energy company for a portion of climate damages amounting to 0.47% of costs of protecting his hometown from glacial meltfloods. We are still awaiting for an appeal judgment in this case, but the first instance ruling showcases how difficult it is for claimants to actually provide proof or evidence of the share of damages that may be attributable to each emitter. Second, the principle of joint and several liability would, as a consequence, ensure full reparation for victims who would otherwise have to identify and sue each contributing state and sue them for their proportional share of damages. And third, and arguably, it could be said that this principle or the application of this doctrine would encourage states to proactively take more mitigation measures in order to avoid potential full liability for the harm caused. The application of the joint and several liability doctrine has actually been implemented and transferred into the domain of public international law and the law of state responsibility in other areas. For instance, we have the 1972 Space Liability Convention, which provides for the victim's right to get full reparation from each state that has jointly caused damages when launching a space object. As well, we have the Annex 6 to the Protocol on Environmental Protection to the Antarctic Treaty, although it has not yet entered into force, which provides for a system of joint and several liability of two or more operators in emergency situation and offering activities in emergency situations, unless an operator proves that the damages have been severable. Accordingly, we can see how proposals of Lex Ferenda have turned into Lex Lata in the domain of public international law and state responsibility. And this has also happened at the domestic level in certain domains. For instance, we can see that in product liability cases or in the private enforcement of competition law claims, where the judges and the judicial practice has needed to adapt to account for these complex causation routes. Despite these considerations that may make it look suitable for the application of the principle of joint and several liability, I also highlight in my paper several challenges that should be considered in order to ensure an equitable approach to the application of this principle in practice. The first concern that I raise is related to equity considerations, considering that the application of this principle may disproportionate, offer a burden on states which have relatively minor contributions to climate change. Second, and most importantly, one of the main gaps that I find in the law of state responsibility is the lack of recourse against other liable states. While it is acknowledged in Article 47 of the Articles on State Responsibility that there is a right of recourse against other liable states, and therefore the states would, in principle, have the right to seek contribution claims from other states that have not had to pay damages to the victim, but who are liable for the harm caused. There are no suitable mechanisms in public international law, and that's the reality, to ensure that states have a right to seek contribution from other states, given the decentralized nature of the international legal order, and also given given the lack of compulsory jurisdiction of international courts and tribunals. This is unless there is an ad hoc agreement, of course, which, for instance, the provisions of the two conventions that I previously mentioned provide for a system of contribution and recourse against other liable states. Third, and besides these challenges that I mentioned, there are other procedural and jurisdictional difficulties that should be borne in mind. To name one, for instance, would be the indispensable third-party problem, or the monetary goal principle in international law, which may play a role and actually may prevail in these situations, considering that international courts would have to engage into the determination of responsibility of other liable states, which may be an issue. And lastly, and as a consequence of all the foregoing, there is an evident risk of political backlash in the participation in international proceedings and international agreements in which this principle of joint and several liability may be applied. So to conclude my presentation, and as a conclusion of all these reflections, I have said that the principle of joint and several liability may be suitable to find a compelling legal solution for the problem of lack of effective redress of victims of climate change at the international level, but international law should carefully adapt for the practical realities that the application of this principle would entail. A balance should be struck between, on the one hand, fairness for states, and on the other hand, the right of effective redress for victims, which in itself is a certainly complex task. But but I have said that these challenges have been overcome in practice, both at the international and domestic levels. So I want to end up with a positive note, and hopefully this will bring about some discussion later on the role of international courts and tribunals to offer acceptable solution to the problem of overdetermination or multiple causation as this problem arises in practice. So thank you very much for your attention, and I look forward to your insights and discussion later.
Thank you so much, Maria. I myself was just enjoying very much, not just your paper, but also the presentation, because touching on topics which are too dear to my heart. But I will not say anything on them right now, because there's interest of hearing from other people in the room. Laura, without further ado, I'll turn to you now for a different sort of beast, but a very important elephant in the room and all of the litigations going on as well, which is precisely this point of intergenerational equity and how to approach, how to give content, clarity to this highly important concept in the context of international climate change regime. So I turn to you.
Okay, so thank you, everyone. It's a pleasure to be here talking with you today. My name is Laura Gonçales. I'm an environmental lawyer and researcher from São Paulo, Brazil. I'm currently working on my master's degree in international law, where I am researching the treatment of children's rights and youth in face of the climate crisis. I'm focusing on youth climate litigation in Latin America, particularly the potential for youth climate litigation in the inter-American system of human rights. So this is a part of my master's thesis, of my research for my master's. Is still ongoing, so I'd very much appreciate any suggestions and thoughts that you have on the topic. I'm going to speak a little today about the challenges we have in approaching youth, children, and future generation interests in international law. This does pop up when we talk about reparations and when we talk about climate litigation, because we need to know who are these reparations for, who is going to benefit from them, and what sort of legal framework do we apply when we seek these reparations. So moving on here, we have a problem to kick us off. We have a problem, and it's based firstly because we don't know, we don't have a common consensus of what we're talking about when we say future generations. So we know that, oh, the environment should be protected for present and future generations. And so many provisions in international environmental law and international human rights law share this overall tone. But we don't have either in soft law or in the doctrine a notion that's commonly accepted as to who are future generations and how do they uh, distinguish themselves from younger generations, such as children and youth. Because we don't have these definition, the language in these documents in international law, environmental law, and in human rights law is very generic and very aspirational. If we look at the early documents in human rights law, these mentions to the future or to future generations are mostly in the preamble of these documents. So it's very lacking in practical applications. And that's the case when we look at the principle of intergenerational equity. The principle of intergenerational equity has become a staple of international environmental law. Since the 70s with the Stockholm Declaration, we see the notion of intergenerational equity become present and develop in these documents. For instance, in the Stockholm Declaration, we didn't have uh, no one used the wording intergenerational equity, but the idea that future generations have interests and have rights in environmental protection and in the quality of the environment is present in the Stockholm Declaration. And this becomes more and more explicit as we go on to the latest documents in international environmental law. So we don't have, even though this is so latent and so present, we don't have the practical applications of this principle. And that is because we don't have the definition of future generations. So when we say that we have to protect the environment for future generations, this lacking definition leads to an openness and to an area that's ready to be developed. And what we have with youth climate litigation is that youth and children and other plaintiffs that are litigating on their behalf, such as NGOs or states and things like that, they seek and they bring forward that courts recognize this problem, which is who are future generations and how can the present generations, if at all, benefit from the principle of intergenerational equity. So in light of this lack of definition and this lack of practical application, there is this open space, and this is being sought after by climate litigation, particularly by youth climate litigation, that are seeking to connect the interests of living younger generations, such as children and youth, with the interest of future generations that have some sort of framework, even though it's not a framework, but that are recognized in international environmental law. That is because we need to note as a step back that we have a very robust human rights law that considers children. We have children's rights as a whole field that it's also very, very robust, very well developed. But the connection between environment and human rights and environment and children's rights isn't exactly easy, even though that we have seen recent developments such as the general comment by the UNCRC and other documents from UNICEF, from the Office of Human Rights in the UN that play to the recognition of the impacts of human rights, of the impacts of climate change and environmental damages to human rights, and particularly the vulnerability of children to these impacts. It's still somewhat very novel. It's not something as traditional or as present in documents in international law as is the principle of intergenerational equity. So there's a benefit to using the principle of intergenerational equity in climate litigation. So with that, we have essentially these three problems. What are future generations? how has the principle of intergenerational equity been applied? Is it being adequately applied, considering that there are no practical ramifications as provided for in these documents in international environmental law, and how these connections are made in youth climate litigation? So the first aspect of the problem is the lack of definition of future generations, because we don't have a definition, as I've mentioned, in international law that is universally accepted, and nor do we have a common definition in doctrine that's also universally accepted. There are different criteria to define future generations, and as a disclaimer, we have to just say that as a common denominator, we can say that future generations are those that have not yet been born. That's standard. We can consider future generations to be that. But we could also expand this definition based on these different criteria. So at opposite extremes of these criteria, we have the criteria of continuous flow and the temporal criteria. When we look at the continuous flow criteria, it doesn't really consider there to be static generations. It considers that there are multiple generations of people currently alive and interacting with the earth in one same historical moment, and that all these people who are from different generations are the present generation, and all those that are not yet born are the future generations. So we don't see, sort of, when we think of generations as age gaps between people, we just have the present generation, that is everyone alive right now, doesn't matter if it is a baby or if it's an old person. These are all present generations, and the future generations are all those who are not yet born. The temporal criteria is pretty much the opposite. It considers that there are generations and that the generation is determined by the moment of which you were born. So after 30 or 50 years, that is the time that one generation takes to replace another in public life, we have these different generations. And these periods of years, they are under discussion, and there's also not a common notion of how long would it take for one generation to go from being a present generation to become a past generation, for one generation go from being a future generation to a present generation. This isn't also very developed. But there are these two criteria, and as you can note in the temporal criteria, future generations could potentially be seen as those who have been born but who are not participating in public life, as the criteria for changing generations is the participation in public life, so in citizenship and things like that. This criteria could potentially include living people as future generations. So it's a lot, and it's a lot of possibilities. And what these two criteria and criterias in between them fail to acknowledge is the arbitrary nation of dividing younger generations, children, youth, and future generations. Because we have to recognize that this division is necessary. In my view, it is necessary, and I can quote a number of scholars that agree with that we should separate future generations and children and youth as groups. But we do need to recognize that there is some porosity and some communication between these groups. And I've quoted here John Knox, his report from 2018. It's a great report. I'm sure that many of you are familiar with it because it's related to the human rights obligations of the right to a healthy environment. And he's very clear in this notion that if we separate future generations and present generations, there will still be some communication. He says that we should think about people living in the future. So people that are going to be living in 2100 is the example that he makes. Many of them have not yet been born, but many of them have been born. So they will have common interests. We can think of that as children who are alive now will be alive in the future and will have interests in this future. And people who haven't been born, future generations who aren't alive, will be alive in the future and will take interest in how the environment will develop by then. And as far as definition goes, we've had some important recent developments with the Maastricht Principles on the Human Rights of Future Generations. These principles consider there to be a separation between children and future generations. They define future generations as those who do not yet exist, but who will exist and who will inherit the earth. So it's very much in line with this proposal for separating children and future generations, but acknowledging that they may have common interests. And we had in 2024 the UN Summit for the Future, which brought forward the Pact for the Future, which has an annex declaration on future generations. And on this declaration, there's also a clear distinction between future generations and children, but the document also recognizes that children, along with future generations, will suffer the consequences of actions and inactions made in the present relating to climate and the environment. So this is where we're at with definitions. We've moved forward from these initial criteria that were discussed, and we have a more openness to the recognition of the arbitrary notion of dividing future and present generations, and we've acknowledged that they have common interests. This is a good point for us to depart from. As for the principle of intergenerational equity, I made in my research a historical account of this principle that I won't go into right now because of time constraints. But the concern for the future has been present in international law, particularly in human rights law, mainly after World War II. And you can see that in the nature of documents in different themes and in different areas, and that international environmental law saw the development of intergenerational equity from the Stockholm Declaration until our most recent documents, and that intergenerational equity is traditionally destined to future generations. Future generations, considering here those who are not yet born, generally. But, sorry. But, sorry. Those who are not yet born. So children are not typically included when we talk about intergenerational equity. So there's also this gap in well, we have in international environmental law, we have human rights law, we have children's law, but children are not quite considered in international environmental law. And the environmental effects or the impacts that a climate damage, environmental damage may have on human rights and on children's rights is also not properly addressed. And this all comes to play when we look at youth climate litigation. I think my time is up, so I'm gonna stop right here, but I'm sorry if I went on a little too long. I appreciate the opportunity to present my research here with you today. And please, if you have any thoughts, any suggestions, do let me know.
Thank you. Thank you so much, Laura. This was a really interesting paper and presentation. Quite struck in particular by the arbitrariness of the gap of 30 years for the renovation of political sphere of an individual. Yes, well, a lot to reflect on. Susan, I think we're turning to you, Susan N, now, and very interesting study, particularly from a methodological perspective, looking into what states have been arguing at the ICJ in the context of the advisory proceedings, which I was particularly lucky to be involved in as well, for one of these states, and to what extent that really translates into the parallel negotiation schemes and trying to really make more robust the mechanisms that are currently in place. So Susan Ann, without further ado, looking forward to listening to you.
Hi, can you hear me? Okay.
Very well. Very well.
All right. And you can see the slides too, is it? Is that
Yes.
perfect? All right. First of all, like my immense gratitude to the organizers and to the chair for this opportunity. My presentation today is largely on a paper which is a work in progress. I'm a lawyer in India, and I'm particularly researching on climate negotiations and COP processes, especially on how social movements are having a say in the advocacy of the negotiations forward. So if I may, like, just give me a second. Yeah, okay. So my entire fascination on the advisory opinion started when I was invited to co-author the book edited by Dr. Maria Antonia Tigre and Professor Armando Rocha, who are two organizers of the workshop here. So when this call for this climate reparations, and I saw it, I was like super excited, and I gave the abstract. So before moving further into the topic, I must give a little background on what fascinated me, especially on reparations. So when I was at Baku for COP29, Azerbaijan, it was just, I had a interesting few conversations around the negotiators who were looking into loss and damage. And they were talking about the rise of the solidarity that they were having with respect to restitution and reparations, and it was high. And it was quite interesting that because after COP29, it was in a week or in a few days that ICJ hearings took place. And the whole conversation around reparations in the ICJ hearings were really high. And I must say that it was really interesting to hear the keynote address, especially Joy Chowdhury mentioned about the oral hearings. But what I would focus here is about more on the written submissions. And so I feel this gives kind of like the premise on how my paper looks into. So when I was starting to write, I felt like the loss and damage mechanism, as we all know, as an emerging de facto space for the climate reparations, though they operate within the political limits of the UNFCCC negotiation space. Now, what I have to stress here is that the caps lock of the or the uppercase of the loss and damage is primarily more of the political understanding. And rather, like when you look into the lower case of the loss and damage, there are so many legalities around it. And to have a say in which both politics and law can merge together, that is where I feel that how does the entire ICJ hearings and the fact of the advocacy for reparations in it is building attraction for the loss and damage negotiations in the UNFCCC COP processes. So my aim for the paper was that it takes an interdisciplinary angle of dealing with more of environmental law and politics together. Now, if you can look into the slide, I've kind of like mapped the problem that I wanted to tackle, especially so, for instance, how climate change cannot be siloed in a discipline, first of all, and how the litigation and advisory opinions and how the international climate litigation sphere is taking attraction in its own level because of the status quo in the UNFCCC COP negotiations. But then how movements around these two spaces are actually making both these spaces quite permeable. So the main argument for the paper is like whether the ICJ written proceedings can provide insights to the need for a greater political consensus and will in the loss and damage negotiations. So we know current NDCs are projected to raise global temperatures by around 3 degrees Celsius, and that it is quite exceeded the 1.5 degrees Celsius target. And does the NDCs that we are actually the states doing, is it quite enough? Absolutely not. But then how does the law come into the place in this whole scenario where, again, we're seeing the political will of the states coming into force more, and the say of that in the ICJ hearings are quite immense. So during the ICJ advisory opinion hearings, the states, the admitted organizations, all of them kind of like submitted 91 written statements and 62 91 written statements and 62 written comments alongside additional NGO submissions. But according to the Earth Bulletin, which was released for the ICJ hearings, they kind of like termed the whole reparations coming in the ICJ hearings as a mantra. Now, why I wanted to say about that or to frame it, the paper as like that, is climate reparations a mantra, is that in Sanskrit, we understand it's the mantra means a slogan, a chant, or a prayer, which is repeatedly rehearsed. So often more religiously prominent in Hinduism and Buddhism, the matter is that a mantra becomes powerful. So it's not just about it is being repeated, but it is repeated in the sense that there is power to the advocacy of it. So this recenters the argument, and as we've heard in the panel before, like what is happening with respect to the 5th board meeting of the Fund for Responding to the Loss and Damage, held at Barbados, is also like interesting to watch as to the nuancing of a political mechanism of the Loss and Damage Fund, and how does the entire climate litigation around it, the request for advisory opinions around it, are actually playing or bringing attraction, say for instance. So the methodology that I've used in the paper is, as I've said, it's a qualitative analysis. I've used 91 publicly available written statements and 62 written comments, which is more of like 153 documents altogether. And I explore how the developing and developed countries articulate the need for climate reparations. And further, and this is kind of part of my PhD research, from a political viewpoint, I look into the UNFCCC cover decisions, and from COP24 to 28, which is the time frame of my PhD research that I'm looking into, the case basis, and looking into the expert interviews around that time. So by triangulating these 3 data sets, I've added the ICJ hearings part just out of my enthusiasm and because of the reparations and how that's actually bringing in attraction for this paper, because of the legal and political pathways that it can force open. So going further, why does loss and damage in the negotiations matter in the first place? So, or why should we think about this interplay of law and politics in the negotiation with respect to loss and damage? So we know that while UNFCCC negotiations are under a status quo, it's kind of like the business as usual. It's happening for a long time. The advocacy on loss and damage has been there for quite some time, but the push around it started mainly post 2015 after the Paris Agreement, and more so post 2018 with respect to the global climate movements that were happening around. So especially in as the speaker just before me spoke about intergenerational equity, I wanted to stress how the youth movements actually played a big part in bringing different global norms, say for instance, loss and damage, human rights, intergenerational equity, all of these together, and there were thematic overlaps in which how normative discourses brought these phrasings and the framings together. So if you look into for an extended period of time on the expert interviews that collected these nuances, we felt that the negotiators were quite cornered by the movements through the normative discourses that were raised and that surfaced throughout. So, and mainly it happened around 3 framings on equity, moral norms, morality, and justice. So again, looking a bit in an iterative process of like, how does reparation and loss and damage link to each other? It is quite interesting, especially with respect to the ICJ advisory opinions, that on climate change being quite multifaceted. There were instances in which the three requests for advisory opinions on to the ITLOS, International Tribunal for Law of Sea, which the advisory opinion came last year, the Inter-American Court of Human Rights, and then now what we have in hand, the ICJ, where there are overlaps, thematic overlaps, that is quite understandable. And some connection with respect to reparations, however, is especially with respect to how the Inter-American Court of Human Rights, especially when they were the Chile and Colombia were stating with respect to the loss and damage, they specifically named mechanisms and practices ensuring restoration and adaptation at every level fairly, equitably, and sustainably. And restoration has been translated as reparations in some documents. And that's quite interesting to note how the entire nuances around it are developing. Now, reparations in itself would in the ICJ hearings. So throughout the written submissions and the written comments of the ICJ advisory opinions for climate change, reparations were repeated continuously. And so I've used the software MaxQDA to qualitatively analyze the mentions of how many times, say, for instance, it gets mentioned. So if you can see what are the top countries, or in the map, like, say, for instance, how it's spread across, you can also not view very clearly, but still the more dark green spots are onto the Pacific Islands, as you can well note. Now, I would stress here that being a qualitative analysis, it will have its errors in the sense that it's more interpretation wise, kind of like an analysis. So it's not a mixed method. So the data have its errors, but it still is largely gives a traction onto how these framings are taking forward. So it is noted how Vanuatu, Democratic Republic of Congo, Antigua Barbuda, Barbados, and African Union comes as the first 5 states that have been the most vocal in advocating for reparations. So these 5 states occupy among the top 10 states that mention loss and damage also, which you'll see in the next slide. But one difference, though, that actually made me note further is how climate reparations were not noted by China, but loss and damage, China comes in the first 10 of noting loss and damage. And then Australia doesn't note reparations either. But for loss and damage, Australia kind of like specifically asks to bring a context-specific understanding of reparations, although it mentions it so. So, and Australia is among the top 10 in the loss and damage. Sorry if I'm not making sense, but I'm just working my way through all the data, and it's a bit kind of like mind-boggling. But a core theme that has arisen is the call for reparative justice to address historical warnings, particularly by former colonial powers. And it's also, it could be stressed here that while some countries like Brazil have mentions of reparations limited, the entire submission have been through the angle of historical responsibility and CBDR, common but differentiated responsibilities and respective capabilities, and equity. So that's why the normative discourse around equity, moral norms of morality and justice have been so strong in the developing countries and least developing countries, as well as small island developing countries. So the high counts of mentions in countries like Congo, Antigua and Barbuda underscores such demand too. But most states and non-state actors refer to reparations by citing international law principle, such as those, as we've heard, outlined in the ILC articles on state responsibility of states for internationally wrongful acts. So a few key findings here with respect to climate reparations. One, small island developing states are vocal, and so are developing and least developed countries. In particular, Antigua and Barbuda stress that while multiple states may concurrently contribute to climate harm, the collective nature of causation does not excuse any single state from making full reparation proportional to its contribution. Barbados, for instance, repeatedly rooted for monetary reparations as the core principle, and Tuvalu stressed further to that, and that states must provide practical adaptation support to help injured states cope with the climate impacts. The second point that I want to note here is that a lot of mention on obligation of erga omnes, that towards all for reparations were made, and that was extremely highly made by DRC Congo. And that comes in the top 10 list also. Another trend that I've observed is also that human rights were had a recurring emphasis to bridge the claims for reparations. Albania, for instance, kind of like stressed international environmental law and human rights law should not stay as siloed. Organization of African, Caribbean, and Pacific Islands stressed about human rights throughout. Ecuador, Solomon Islands, and Brazil, and Cook Islands, they were they brought the normative discourses around reparations through the human rights angle. Another trend was that the support from some developed countries were very much noted, but through their vocal or how they vocaled through non-state actors like civil society organization, third sector organizations like IUCN, they kind of like championed it. So there have been like transnational organizations or advocacy networks wherein which it was deeply observed how the global north-south binaries were actually they crumbled, the walls crumbled. So and the last point that I wanted to note with respect to climate reparations was that most of the developed countries rehearsed again the ILC report, especially on Articles 30 and 31, that the establishment of a causal link between the anthropogenic emissions of greenhouse gas emissions into the atmosphere and the occurrence of specific harm constitutes a specific challenge. So US, for instance, asked to take a context-specific understanding of reparations. Netherlands, EU, we see how the trends of reparations were actually framed. Now, going to loss and damage, very quickly, I know I'm 15 minutes and more into the thing. It's interesting how one of the expert interviews kind of like said that it's a long fight that came with 2 steps forward and 1 step back. So I think that sums up about how the loss and damage hearings, loss and damage negotiations in the UNFCCC COP processes took place, and how the political sensitivity around reparations or loss and damage and the whole idea of it made loss and damage negotiations look forward for ways in which solidarity was enhanced. So here, in the ICJ hearings, again, in the written submissions, there were a few aspects that I wanted to stress, just 3 maybe, that how did, so bringing moral norms to the forefront, reparations initially were going beyond a normative framework where international law on reparation is bolstered through the angle of human rights, and that was seen. And loss and damage, though having a political sensitivity, had many claims of how it can bolster more or less like an interplay of law and politics together. So with that, I come to the conclusion that three things that I've observed. So the potential of loss and damage litigation, I'm yet to observe it, but then there is the entire increase of climate litigation, as well as the exploration of loss and damage around it coming into play. The role of youth, as you've said, so we do have traction through indigenous movement, the women movement, gender movements of all sorts. And there were a lot of interesting aspects that go along in the UNFCCC COP spaces, like say, for instance, the youth negotiators there, they bridge the entire aspect of bringing the movements and collaborating with the negotiators and elevating the normative frameworks forward. And then the third aspect is the role of human rights. So how right to healthy environment is bolstering a lot of consensus around it, and how, again, the climate litigation in most of the global South countries are having more of a say through a human rights lens, because vulnerability no longer becomes kind of like a vulnerability, but it becomes the agency to transform change. So yeah, thank you.
I think a very fascinated and kind of introspective account. Yesterday during a drink, I've heard from someone that someone very experienced who worked for many, many years for the Canadian government used to say, whenever one wears the hat of a practitioner or has to plead before any court or tribunal on behalf of the government, you feel like a plumber of international law. So you try to fill in some gaps out there and be strategic about how you do that. I don't think people have in mind how then subsequently, in terms of quantitative and qualitative analysis, one is exposed out there on these graphs. But it just, I couldn't stop but thinking about that when you were showing those graphs. But another exciting point, I think, is that there is clearly an overlap in terms of those different color shades between the references to reparations more generally and to loss and damage. It seems like the same countries have picked up and developed maybe more detailed arguments on both, right? And the impression of the mantra being in the room was actually that it wasn't that much of a thick mantra, I would say, because out of the two questions before the court, the states focused way more on the first question in terms of what substantively are different obligations of states in respect of climate change. And I did feel that there was a lot of fudging and nudging on the corners in terms of one would get to question B. And I think there was a strategy there in terms of states, and maybe part of the strategy why states were reluctant to say so much more on question B was just look at the terms, how the question B was framed, and some of the terms there, well, you're not quite on a sure ground. So, anyways, this is just a food for thought. But turning to our last but not least speaker, Marco, who will add a little bit of the finesse to another parallel discussion which happened in the advisory proceedings, both at ITLOS, but in particular at the ICJ, on the relationship really between the climate change legal regime, but also the whole parallel universe of customary international law, and in particular, the principle of prevention. And Marco, the floor is yours, and we look forward to listening to your presentation. Very well.
Yeah, it's a privilege and honor to be today with you, and I thank you for this opportunity, and I thank to the speakers of the group. Every single one of them touched quite interesting topics. So I hope this last addressing now will be just a normal consequence of the whole issue. We're all in a weight of the advisory opinion of the ICJ. So while I was following the oral submissions and the written arguments, it was obvious that, as you said, there was some kind of strategic approach by the countries. There were countries that were supporting the prevention principle, there were countries which were in a way neglecting it. There were other countries which were not really clear if they have certain obligations regarding the UNFCCC, the Kyoto Protocol, and finally the Paris Agreement as lex specialis, contrary to the lex generalis. So I will, since I mean the whole issue before the court is quite huge and challenging, I will try to put it in few minutes, even though it's quite impossible, as state responsibility is quite intertwined with the prevention principle and the whole topic. However, my core interest in this matter is I'm interested actually in a way I cannot sleep thinking how the court will interpret these arguments, because every single state gave well-founded arguments. I cannot really say that somebody is not right or somebody is really right, you know. And it's the ICJ and they're responsible states, so we saw that the arguments were well-founded. So first, the ICJ under its statute may give an advisory opinion on any legal question at the request of whatever body may be authorized. And we all know that the international legal regulation on environmental harm on the atmosphere is now predominantly treaty-based. So the prevention principles started initially from the Stockholm Declaration, the Principle 21, then the Rio 2 Declaration, and then continued finally with the trail smelter arbitration, where it was the cornerstone case, even though it was not from the ICJ, but still it was about harm on foreign territory. Then it became customary law from the Rio Declaration and on, especially in the pulp mills case, then in the Coffee Channel case, and as I mentioned, the trail smelter arbitration, which continued to be cited and used in the following period. So we are now witnessing that every single issue we have with prevention principle is connected with pulp mills case, with Gapchico and Aguimaros, with Silala River case between Chile and Bolivia. Then we have the Nicaragua and Costa Rica. So we see that there is some kind of customary international law, in a way, responsibility for the states under they which need to conduct. So these cases which I mentioned were generally referring to the application of the prevention principle. Now we have the three most cited documents in the oral submissions and the written submissions, which were the UNFCCC, the Kyoto Protocol, and the Paris Agreement. And all these instruments refer to the GHG emissions. But part of the states which gave their oral submissions there were in a way neglecting these obligations between the fight of, as I mentioned, lex generalis versus derogat lex specialis. So nobody was really sure if they should abide the Paris Agreement or they should abide the previous treaties which are signed and which are actually customary international law. However, prevention principle is customary international law in the practice of prevention of treaties and in the practice of the court. Therefore, states have a duty to take appropriate measures to prevent, reduce, and control transboundary pollution and environmental harm. And states also have duty to cooperate in mitigating transboundary environmental risk and emergencies. So another thing for the GHG emissions is because it's invisibility. You know, it's not something that is directly visible. So states, because of that, probably are reluctant to agree that the existence and the severity of it. because it's not like pollution of water, like pollution of soil or something else where you can easily prove, even though it is proved with the GHG emissions what's going on, but still it's kind of away from states, and nobody wants to admit it openly. The existence of the general obligation of states is to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control is part of the corpus of the international law. So the United States previously have stated regarding Principle 21 that it did not in any way diminish the existing international responsibility for damage to areas beyond national jurisdiction. And obviously we have practiced even from previously that states openly acknowledge the prevention principle. Not that we are expecting it to happen now, but there are separate opinions, and there are dissenting opinions of judges in the ICJ, especially where they're backing this opinion on the customary international law regarding interpretation. So the UNFCCC, for example, defines the meaning of the emissions. The Kyoto Protocol also has the Annex 1, which imposes certain obligations to the parties. And the Paris Agreement, despite much contention, it was agreed that it's legally binding. So the interpretation of the treaties now, the interpretation of treaties and all these arguments is now what's going to be quite important, because previously we had from last year the International Tribunal advisory opinion, which was quite significant, and it reflected quite much on the prevention principle, even though it was related to the marine pollution. Nonetheless, still it paved the way for countries and courts to consider it as a relevant opinion, juris, and practice of the states. So undoubtedly, it will be Article 31 of the Vienna Convention of the Law of Treaties, and in good faith, the treaty should be construed according to the common interpretation that should be applied. And we, at least I am wondering how the court, which approach will take, because there might be use the evolutive approach in the interpretation of treaties, even though it's known for the European soil in general, but still might be of great use. Then we have several meaning of the principle of interpretation of treaties. It may be restrictive, it may be expansive approach, it may be approach which will take into consideration all other possibilities, and it will employ all the knowledge and the experience and the case law practice of the international courts, for example. And this kind of practices is well known in the Gabčíkovo-Nagy case and the pulp mill case, where it's quite important that when interpreting the judgment and the reasoning, the legal argument, the arguments were not, the treaties were not taken as static, but they were rather given a possibility to be implemented in today's circumstances. Because there is no treaty, there's no legal instrument which can anticipate to detail what's going to happen in a near future, and not speak about distant future. So it will be quite interesting to see how the court will apply these rules of Article 31, where the existing case law, the existing customary law rules, the whole legal scholarship in this area will need to be implemented. Of great attention, several.
If I may just ask you, sorry, Marco, if I may just ask you in the next 2 minutes or so to conclude, so we can open up a bit for discussion. Sorry.
Right, yeah. Yes, we have the draft conclusions on subsequent agreements and subsequent practice in relation to interpretation of treaties. Then we have the draft guidelines on the protection of atmosphere from 2021. The analogy of the request of the advisory opinion is quite interesting and I believe quite significant in this matter. And then the ILC draft conclusions on identification of customary international law because some states disputed what is customary international law, what is not. And then finally, we have the prevention of transboundary harm from hazardous activities. So the implementation of all of the experience and the legal practice and the practice of this work of the International Law Commission and the practice of the ICJ and the states will should give the court a standing to render an advisory opinion which will be sharper and which will finally level up the existing situation on environmental in environmental issues. So apologies if I went over 15 minutes. I'm open for questions.
Thank you so much, Marco. Thank you so much.